Hi, everyone. My name is Annie Rogers, and on behalf of the ADDitude team, I am pleased to welcome you to today's ADHD Experts presentation titled, Are My Students' ADHD Accommodations in Danger? Fallout from the Department of Education Changes. Leading today's presentation is Mary J. Goodwin-Oquendo. Mary is a disability civil rights attorney, an adjunct professor of law at Fordham University School of Law, and the founder of the Goodwin-Oquendo law firm. For more than 15 years, Mary has advocated for individuals with cognitive, physical, and psychiatric disabilities who have experienced discrimination in school and/or require accommodations for high-stakes admissions and licensing examinations. Mary is a member of the New York State Bar Association and an appointed member of the association's Committee on Disability Rights. She is also a member of the Disability Rights Bar Association, the New York City Bar Association, and the American Bar Association. We are lucky to have her today. We would like to begin by just taking the temperature with a poll question to our live audience. We'd like to know, on a scale of 1 to 10, how concerned you are that the changes at the Department of Education will impact the accommodations and/or services that your child or your students receive. 1 is you're not at all concerned, and 10 is that you're extremely concerned. This will help us get a sense of where everyone is today. Please select your answers and comment in the text box under the video player to tell us more. For answers to common webinar questions about slides, transcripts, and certificates of attendance, click on the FAQ tab of your webinar screen. And if you support the work we do to strengthen the ADHD community, we encourage you to subscribe to ADDitude magazine. Sign up today and you'll receive the summer issue. It's our first ever women's issue and it hits newsstands in early May. Subscribe today and you'll get 15% off your order plus a free copy of the ADDitude ebook, How the ADHD Brain Works. Click the link on your screen to get 15% off ADDitude and your free ebook now. Speaking of ebooks, please know that our online store has several ebooks on ADHD in school, including the complete IEP 504 guide, a parent's guide to ADHD at school, and for educators, how to teach and inspire students with ADHD. You can find all of these and more at the ADDitude store, additudemag.com/shop. Ooh, that's tough. Without any further ado, I am so pleased to welcome Mary. Thank you so much for joining us today and leading this very timely discussion.
Thank you so much for having me. I do just want to start with a disclosure. This presentation is provided for informational purposes only and is not to be construed as legal advice. So if you have any questions about your specific circumstances, please reach out to an attorney. Have we had an opportunity to get that poll data back about, on a scale of 1 to 10, how anxious people are?
Yes. Okay. So it is, okay. So 44% of people gave it a 10.
Oh, wow. Okay.
Right. And only less than 1% said not at all concerned. So it does seem, if I'm eyeballing it, that our average would be about a 7.5.
So what I will tell everyone is let's take a second to inhale and exhale. When I first saw all of these changes that were being proposed and that were being made, I too was at maybe a 20, freaking out about what would be the immediate impacts for my clients, what would be the long-term impacts. But in preparation for this program and also to advise people, I did a deep dive, and I'm happy to report that we have to be worried, but we shouldn't feel like it's a 10, right? We have to approach this crisis, if you would call it that, with less emotion, and we have to be more methodical, right? Like we have to plan, we have to strategize, we have to be educated. So that is what I hope to I hope to give you those tools or some of those tools for today's program. Okay. So how do we evaluate the potential DOE fallout? First, let's understand how federal laws are made. Let's understand the requirements of existing federal laws, meaning the IDEA and 504. Let's understand the responsibilities of the DOE under existing federal law. Let's understand the role of agency regulations and guidance. So an agency would be like the Department of Education. And then let's understand the roles and responsibilities of individual states. Once we do that, then let's consider agency or regulatory changes that are being proposed or implemented, right? Some of these might be proposed directly from the agency or the secretary leading the agency. Some of them might be proposed via executive order, as we'll talk about in a few moments. Then let's consider recent and pending litigation, right? So we can see what case law has been established and also what case law might be coming down the pike. And then let's look at any new legislation that is being proposed by Congress. Once we do all of these things, then we'll have a realistic assessment of how to approach the Trump administration's their agenda for the Department of Education and for people with disabilities. Here is a neat little infographic that I usually share with my law students, and I'm sharing it with you because I think it's good to visualize the legislative process. So the first step when we're talking about legislation is having a representative sponsor a bill, meaning a senator or a congressperson, like House of Representatives member. The bill then is assigned to a committee for study. It is then released by the committee and put on the calendar to be voted on, debated, or amended. If the bill passes by a simple majority in either house, then the bill is assigned to another committee, and then it's released, debated on, and voted again. And again, we need a simple majority by the second house. Finally, a conference committee made of House and Senate members works out any differences between the two different versions of the bill that may have existed in the Senate and the House. Then the resulting bill goes back for final approval. Then the government publishing office prints the revised bill, and then the president has 10 days to sign or veto the bill. This process can take sometimes a couple of years, right? Depending on when a bill is proposed. This process can sometimes be immediate, depending on how much cooperation there is between the different houses and or the president. Presently, the Republicans control both the Senate and the House, and they have not been particularly opposed or resistant to what the Trump administration is proposing, and many members themselves have proposed bills or other things that follow like a similar line of thinking. So while it is possible, of course, that a bill can be rushed through, this procedure does allow multiple opportunities for the public to give their 2 cents. You can do that formally by testifying before a committee or testifying on the floor of the Congress, or you could write letters to your congresspeople. There are so many different ways for your voice, for our voices to be heard during this process. So I just want everyone to keep that in mind. So now let's talk about the IDEA, the Individuals with Disabilities Education Act, which I'm sure many of you may already know. It was originally called the Education for All Handicapped Children Act, and it was passed in 1975. It was renamed IDEA in 1990. What does this statute do? It provides a FAPE, free and appropriate public education to eligible students with disabilities. That includes early intervention, special education, and related services. When we're talking about early intervention, we're talking about ages 0 to 2, meaning birth to 2 years old, and like speech therapy, occupational therapy, physical therapy, special education, that's ages 3 through 21, and related services, pretty much the same things provided for early intervention, but for ages 3 through 21, including transportation, etc. Also, IDEA describes specific categories of eligible students. We know for many students with ADHD, when we're talking about IDEA, they typically fall into the other health impaired category. Also, the IDEA authorizes formula grants and discretionary grants. And formula grants are non-competitive awards based on predetermined formulas determined by Congress. And these programs are sometimes referred to as quote unquote state administered programs. And then there are discretionary grants, which are competitive. And a panel actually decides how these resources will be allocated. Then the statute also governs actions by agencies and states. And it identifies the Department of Education and Secretary of Education as responsible for implementing the statute. Here are some examples of safeguards within the actual language of the IDEA, meaning the statute. So the statute says that there must be an Office for Special Education and Rehabilitative Services that is commonly referred to as OSERS. What OSERS does, it supports programs to help educate children and youth with disabilities and provides for the rehabilitation of youth and adults with disabilities. It provides a wide array of supports and services to parents, individuals, school districts, and states in the areas of special education and vocal rehab. Then there's also OSEP, right? Office for Special Education Programs. And what OSEP does is it administers the IDEA by authorizing formula grants to the states under Part B of the IDEA, right? That's what most people are dealing with, ages 3 to 21. Grants to lead agencies for infants and families under Part C, right? And then also discretionary grants under Part D to institutions of higher ed and nonprofit organizations to support grants for state personnel development, technical assistance, technology development and dissemination, etc. Another safeguard within the language of the statute is that there are requirements for prescribing regulations that shall not violate or contradict the statute, meaning the Secretary of Education cannot create regulations that violate the IDEA. That is written into the language of the IDEA. And similarly, the provisions with regard to policy letters and statements and explanations and assurances says that the Secretary of Education cannot issue any informal statements that contradict the IDEA. They must always indicate that, let's say they're dear colleague letters or anything else, that those items are not, they don't outweigh the regulations or the statute. And also they must indicate that any determinations that are made public are related to that specific case at hand. It's not to be considered as precedent and applicable to other cases. This is helpful, especially now when we're dealing with maybe a Secretary of Education that has a drastically different opinion and approach of how the IDEA is to be applied. In short, what you can see here is that within the actual language of the IDEA, there are these safeguards that create stability over time and across administrations. In order to change these things that I just listed, there will need to be an amendment to the IDEA, and they'll have to undergo the legislative process that I described in my earlier slide. So it's also helpful for you to understand what the IDEA demands of states. So here I've just highlighted some of the things that it demands of states. There are many things, quite frankly, that they demand of states. Anything that the state does must conform to the purposes of the statute, meaning the IDEA is essentially the bare minimum of protections that can be afforded to students with disabilities. The statute also says the states must identify in writing to local educational agencies located in the state and the secretary any such rule, regulation, or policy, such as a state-imposed requirement, that is not required by this chapter and the federal regulations. The chapter meaning the statute, and the federal regulations meaning the regulations to enforce the IDEA. Also, states must minimize the number of rules that they have to which local educational agencies and schools located in the state are subjected to under the chapter. And then lastly, state rules, regulations, and policies under this chapter shall support and facilitate local educational agency and school level system improvement designed to enable children with disabilities to meet the challenging state student academic achievement standards. What this means practically is that states already have, at a minimum, laws in place that are consistent with the IDEA. So if like worst case scenario, the IDEA were to be amended in a way that would grant lesser protections, there's a buffer there. Now, some states offer greater protections than others. That's something that you would need to inquire with your local representatives. But this is still good information to know. The IDEA also has certain requirements for states wherein they have to demonstrate certain things to be eligible for funding in a fiscal year. This includes submitting a plan to the DOE secretary showing that the state meets the statutory requirements for FAPE, remember, free and appropriate public education, full educational opportunity goal, child fine, IEPs, least restrictive environment, procedural safeguards, evaluation and confidentiality, private schools, personnel qualifications, performance goals and indicators, participation in assessments, maintenance of state financial support, etc. So, in a nutshell, that is the IDEA. Now let's talk about Section 504 of the Rehabilitation Act of 1973. This is a law that prohibits recipients of federal financial assistance from discriminating against and excluding qualified individuals with disabilities. Unlike the IDEA, which is only applicable for grades K through 12, 504 applies to all schools, right? So it doesn't matter if you're elementary, middle school, high school, post-secondary, meaning, undergraduate, college, grad school, law school, medical school, etc. All of these institutions may be subject to 504 if they are receiving federal financial assistance. Students who are ineligible for IEPs may indeed be eligible for 504 accommodations. As stated previously, IDEA does have these specific categories that students' impairments must fall under. And if for some reason someone's impairment doesn't fall under other health impaired, they may nevertheless, or that they demonstrate that they need special education and related services, they may nevertheless be eligible for accommodations under 504. The DOE has regulations, and the Office for Civil Rights, OCR, is responsible for enforcing 504 for all schools, all levels. But I will also note that other federal agencies also enforce 504, because 504 doesn't just apply to students, it applies to anyone with a disability who is employed at an institution that receive federal financial assistance, that they are in some form or fashion participating in a service or activity provided by such an institution. They're also protected. As I'll discuss in a few moments, Health and Human Services has its own 504 regulations. We've actually seen a lot of activity there that may impact how 504 is interpreted as related to schools in the K through 12 and post-secondary and professional education universe. So now let's compare 504 versus IDEA. 504 is, well, let me backtrack for a second. The IDEA is a very, very detailed statute. Very, very detailed. As you can see by the brief outline, that was not so brief that I just gave you, of some of the key provisions, but it's very, very detailed. 504, on the other hand, it's not a standalone statute. It's a section of the Rehabilitation Act. And a lot of people think of it as an afterthought, which it kind of was. So this text that I have here is it. That is just 504. And I'll read it to you. Section 504. No otherwise qualified individual with a disability. Note it says qualified handicapped individual because that was the original language and that was what was used then. But I'll say, individual with a disability in the United States, as defined in Section 7(6), shall solely by reason of his or her handicap be excluded from the participation in or be denied the benefits of or be subjected to discrimination under any program or activity receiving federal financial assistance. Again, that's it for 504. So you might see that and think, okay, great, right? It's less detailed. That means that there's, greater protections there. Well, there are pros and cons to this. Thankfully, 504 regulations fill in the gaps. And what I've seen in reviewing this is that a lot of the regulations that have been implemented align with what the IDEA already provides in the statute. So you'll see references to FAPE, free and appropriate public education, for post-secondary and for K through 12, and anyone who meets academic or technical requirements for admission or participation must be accommodated. You'll also see details, information about what's a discriminatory action, right? Like what's prohibited, what assurances must be made by location and notification, educational settings, evaluation and placement, procedural safeguards, non-academic services, preschool and adult education, reasonable accommodations, academic adjustments, remedial actions that must be taken when there are when discrimination has been identified, voluntary actions, grievance procedures, etc. Also, the regulations state that compliance with the regulation is not excused by state or local laws limiting eligibility. So, IDEA states essentially have to opt in and they have to comply. 504, yeah, in a way they're opting in because, they're receiving federal financial assistance, so they're on the hook, but it's less specific. So it is possible that there might be a state law that on its face is less accommodating than 504. But again, that's no excuse because the federal laws are almost always considered the floor as far as what is required by the law. Okay, so 1 second, apologies for that. So now that we've covered IDEA and 504, I think it's only natural that we understand the statutory responsibilities of the Department of Education, which I'm referring to here as DOE. So DOE is responsible for issuing regulations and guidance documents, right? Regulations, that's straightforward. Guidance documents, that actually helps you to interpret the regulations, and the regulations help you to interpret the statute. So that's helpful. There are also Dear Colleague letters that are issued and other points of clarification that the agency is able to publish. OSEP and OSERs, again, those must exist within the Department of Education pursuant to the language in the IDEA. And then the Department of Education, via the Office for Civil Rights, must investigate discrimination, retaliation, and harassment. It can also take on cases and litigate on behalf of individuals, but at a minimum, it must investigate discrimination, retaliation, and harassment. That is by statute. So if someone submits a complaint, the Department of Education must follow through, or else they are in violation of the statute. So how have IEP and 504 issues and concerns commonly been handled up to this point? I think it's important for us to look at this and ground ourselves, because we're concerned about losing things. Let's see what we have. So communication between parents and staff, including teachers, guidance counselors, and principals, that is the most informal way the issues have been handled. It is recommended, right, that if you can resolve these things informally, that you do so. Then there's mediation. Then there are state complaints that have been filed, or can be filed rather, impartial due process hearings, OCR complaints, and litigation. So let's start back. Let's go through this list again and see who is responsible for what. Mediation, the state has to pay for. This is a part of the statute. The statute says, particularly the IDEA, that the states must have in place processes and procedures for handling these disputes, and that includes mediation. State complaints, if you're filing a complaint with the state, those must also be investigated, regardless of what's happening with the Department of Education down in DC or in the local US DOE office. Also, impartial and due process hearings must be paid for by the state. The state is responsible for selecting and training officers. So all of this will be operating independently, even if, theoretically speaking, the DOE is going up in flames. OCR complaints. Now, this is unfortunately a situation where if the DOE is not handling OCR complaints, the states don't pick this up, because this is solely within the domain of OCR. And then litigation. This is something that you can do. You can sue in state court. You can sue in federal court, depending on your needs. There isn't always a requirement to exhaust administrative remedies, especially if you feel that doing so, or can establish that doing so, would be futile. But these are overall your options. Now that we've done that, let's look at the relevant changes made and or proposed by the Trump administration. As you'll see when I'm going through this list, not all of them appear to target disability, but I mention them because there's impact to people with disabilities. The first is the February 14th, 2025 OCR Dear Colleague letter targeting DEI. So remember, Dear Colleague letter, this is a form of guidance that it helps to clarify how the current secretary, the current administration is interpreting the law, but it is not dispositive. But anyway, in this letter, pretty much the secretary, the OCR secretary, said that DEI was discriminatory. Guess what? If you didn't know, people with disabilities fall under DEI, especially when we're talking about post-secondary education. So while race and gender were the focuses of this letter, if DEI gets thrown out, that will absolutely impact people with disabilities. So that's something to have on your radar. March 2025, the Trump administration closed more than half of the Department of Education's OCR offices with little notice, pretty much messaging people saying, hey, tomorrow, don't show up. And then those offices that have remained open have seen a dramatic decrease in staffing, where essentially they are functioning or not functioning with the skeleton crew. I do a lot of work with OCR in my practice, representing individuals with disabilities in post-secondary and professional schools. I had clients or have clients, I should say, who had existing complaints that were, they haven't received a response. I had clients who their complaint was in the middle of mediation. No progress has been made. These are the immediate impacts for people with disabilities. This is not something that the majority of, I would say, K through 12 students would immediately feel. But those K through 12 students that are dealing with harassment issues and retaliation issues, that's something that you have to go to OCR or sue to get addressed. So unfortunately, those students will be affected. Those families will be affected. Then March 20th, 2025, President Trump issued an executive order titled Improving Education Outcomes by Empowering Parents, States, and Communities. This executive order called for the closure of DOE overall and returning the main functions to the states. It also, again, called DEI discriminatory and illegal. This is not something that Trump or his Secretary of Education can immediately do. It's their agenda, though, so that's something to keep in mind. But legislation, we need legislation in order for the functions of the DOE as related to IEPs or other things, for those to officially, through a legislative process, be shifted to states. You can't just, with the stroke of a Sharpie or a pen, say, it's no more Department of Education. Statements like this and executive orders like this, I think, are easy ways for the Trump administration to amp up their base and also disorient people who would be affected by this. Don't fall for the disorientation trick. Okay, so then March 21st, 2025, Trump announced that he planned to shift the quote-unquote special needs program and oversight to the Department of Health and Human Services. Same thing. The statute, the IDEA itself, says that the Department of Education is where special education matters are to be handled. So for him to say he's shifting it to Health and Human Services, he can't just do that by announcement, by decree, by executive order. There has to be a legislative process. Also, I recall that the acting Secretary of Education, Linda McMahon, made a comment, I believe it was her, that, well, it's no big deal with this all being shifted to HHS because it used to be handled by HHS back in the day. Back in the day, it wasn't just Health and Human Services, it was Health, Education, and Workforce, if I remember correctly. Like, that was the agency. So to send this to an agency that does not deal specifically with education now in 2025 would be very misguided. Now, April 9th, 2025, there was a presidential memoranda issued directing the repeal of quote unquote unlawful regulations. This is something that definitely rang an alarm for me because, again, for a lot of laws, regulations are how these laws are enforced, right? Section 504, for example, it was passed in 1973, but it took about 4 years for regulations to be issued. So for 4 years, people with disabilities could not avail themselves of the protections of 504 because there were no enforcement regulations. And it was through like a lot of protests, a lot of sit-ins, etc., that pressure was applied and these things were passed. So there's power in regulations. And that is one way for the administration to modify or rather restrict the breadth of a statute without repealing the statute. But if we look at the IDEA, the statute itself also says no regulations may be issued that are contrary to what's outlined in this law. So I really think the IDEA will benefit from being a very detailed law. Then April 11th, just 2 days after that, the Office of Management and Budget started to solicit ideas for deregulation. So they did a public notice, and they said, hey, if you feel that there's a regulation that we should recall because it's causing you a headache, let us know. So I do expect that over the coming months, we will see specific regulations targeted more and more for not just repeal, but also revision. Whenever you have a regulation that is being proposed or revised, there's something that's called a notice of proposed rulemaking. And what that does is it gives the public an opportunity to participate in the process. So you'll have a certain amount of time, like maybe let's say a couple of months, where you can submit a letter as a stakeholder explaining what your preference is, what your experience has been, and it becomes a part of the public record. And then the regulatory agency, then when they decide what the final rule will be, will usually give a breakdown. Okay, well, here's what was submitted. Here's what people were concerned about. Here's where we're landing on these issues. So again, this is something to keep an eye out for. You know, I do anticipate that over the coming months and for sure over the coming years, there will be opportunities for people to submit commentary regarding these proposed regulations. And it's one way just to make sure that our voices are being heard. So then lastly, April 11, 2025, Health and Human Services issued a clarification regarding the preamble of regulations issued in May 2024 with regard to gender dysphoria. So gender dysphoria was included in the preamble, but it wasn't included in the regulations. And this has triggered a lot of states and a lot of individuals on the right. And that made the entire regulation a target, right? Pardon me, I didn't clarify. The regulations had to do with 504. So it's a disability regulation, and gender dysphoria has been considered by many to be a disability. Whereas, you know, being transgender, that is not a disability, but gender dysphoria is. And the Trump administration and the right really wants to walk that back. So here are a couple of cases that may threaten the rights of people with disabilities. It really depends. So Loper, Bright Enterprises v. Raimondo, this was a Supreme Court decision from last year. And what it did was it overturned the Chevron doctrine, which stated that courts should generally defer to the regulations issued by enforcement agencies like the Department of Education and, you know, Health and Human Services, etc. So what this does is it gives the courts more discretion in deciding how a statute is to be interpreted in many cases. And disability law, you know, I'm thinking of the ADA, which I didn't really discuss today, but in my day-to-day work as an attorney, I deal with that a lot, predominantly even. And the regulations have been key to making sure that people with disabilities understand what their rights are and that covered entities understand what their obligations are. Like, I think it's a really useful handbook. Texas v. Becerra, which is now Texas v. Kennedy, because Becerra was the prior Secretary of Health and Human Services. You know, this has to do with what I just mentioned in the prior slide, right? Gender dysphoria being mentioned in the updated regulations. In this particular case, I believe it was 17 state attorney generals that joined this litigation, and they have actually argued that Section 504 should be considered unconstitutional, which is crazy. They're saying that it's an overreach. You know, all of the arguments that they have articulated, you know, it's kind of detailed. It can be its own webinar, so I won't go into that. But what you should know is that they're questioning the constitutionality of Section 504. And even though their target was gender dysphoria, they're kind of taking a scorched earth approach. Now, when people started to learn about this a couple of months ago, there were press releases issued, and then the plaintiffs really tried to walk it back a little bit and say, no, we're not saying that we're trying to get rid of 504. We're just focused on gender dysphoria, what was in the preamble, etc. But they have not amended their complaint, at least as far as I'm aware. They have not amended their complaint and their prayer for relief that Section 504 be deemed unconstitutional. So clearly, if Section 504 was to be deemed unconstitutional, there would be a lot of blowback for that, right? For all people with disabilities in a variety of settings. But we think it's a weak argument, but the case is in Texas. So, it has to do with Texas, so we really don't know. Now, are IEPs and 504 plans in danger? After this presentation, I hope you'll agree with me that immediately it's unlikely, but over the next several months and years, it's possible. That would really depend on whether Congress, which is presently controlled by the party of the sitting president, Republicans, passes legislation and or the federal agencies amend regulations, which it seems they're planning to do, right? Recalling regulations, rather repealing them, amending them, etc. OCR and federal agencies, again, are being intentionally understaffed. That has already had an immediate impact. So maybe not for IEPs, but for those students who are experiencing harassment and retaliation, OCR being understaffed has been an issue. And for those post-secondary students who need accommodations, who also have been retaliated against or experienced discrimination, this has been an issue. Now, there's precedent against this, right? I believe the case is Adams v. Richardson. That was a civil rights case, and it had to do with OCR investigating race-based complaints. And in those, in that particular situation, OCR was understaffed. They said, well, that's why they couldn't investigate the complaints at all or in a timely fashion. But with this case, the court determined, no, that's not an excuse. You need to hire the necessary staff. Before I move on to the next slide, there was one other case that I actually just learned of last night. So this case was filed April 21st, 2025, and it was brought against the United States Department of Education in the U.S. District Court for the District of Massachusetts, and it was brought by the Victim Rights Law Center and a couple of parents on behalf of their children. These parents filed complaints of retaliation and or harassment with the Department of Education because their minor children were being discriminated against on the basis of disability and or race. And the cases are going nowhere because the office is closed down, things are understaffed. So this is definitely a case to watch. What can you do to be proactive? You can track executive orders and memoranda, pending legislation, the notice of proposed rulemaking, the NPRMs that I mentioned previously. You can look for clarifications that are issued by the heads of various agencies and any other notices that may impact education. Also, check out those things that may not impact education, because the, let me go back here, Loper Bright, that case and the Chevron case as well, those cases didn't have anything to do with disability. They had to do with regulations, but because it impacted how all regulations are viewed, it impacted disability. So just keep your ears to the ground, and then communicate with your school district and state Department of Education. For those who are educators on this call, communicate with families, right? I think transparency is important here. I think patience on both sides is important as people try to, navigate any changes that might come down the pike. Document any concerns in writing, particularly if you're an individual with a disability or the parent of an individual with a disability. Document. If you have any questions or concerns about anything, consult an attorney. You can consult an attorney before the house is on fire. You can consult an attorney just to make sure that you understand your rights and your options. Engage your state representatives. Make sure that your state has laws that are equal to or better than the laws that we're worried about the federal government harming, right? So IDEA, 504, ADA. For example, in New York State, our state human rights law is much broader than the ADA. So what's going on in your state? Contact your representatives, see what exists, see what they have planned, and then collaborate with like-minded individuals and organizations. One thing that you'll see is that when 504, for example, didn't have regulations, and even when the ADA was being passed, broad coalitions are what helps to move the dial on these things. So let's not operate in silos. Let's work together. Here's a list of resources for you to check out to implement some of those action items that I just mentioned, right? So I don't know if you can see the cursor here like I can, but this website is for executive orders. That's a government website. Tracker for legal challenges to Trump administration actions. That's not a government website, and it will probably be a wonderful resource going forward as there are more and more challenges. Additional links here for pending legislation, to access congressional proceedings. You know, you can watch these things. You can watch these hearings that I mentioned and like some of this testimony that I mentioned earlier on. It's available on C-SPAN, even stuff from back in the day, existing law, judicial decisions, and then special education information and resources for your state can be found at the second to last link. And then find your federal, state, and local representatives. That is something that you can do for the very last link here. And that's it for me. I know that I went a little bit over time. I'm sorry, but I'll hand it back to you.
Mary, oh my gosh, that was so comprehensive and clear. Thank you so much. I think as a non-legal scholar, definitively non, I know that, you know, part of the overwhelm here is the layers of agencies and regulations and honestly, things that for my entire lifetime and now as a parent, I've taken for granted. And now we are getting caught up to speed, all of us, very quickly on all of this. So this was really helpful as a primer, and also giving us some next steps and helping everyone feel empowered to help. Okay, so to launch into our questions, I wanted to start with a basic one, and that is, generally speaking, the IDEA and 504 regulations apply to public schools only. Is that correct? And are there any circumstances under which private schools may also be impacted?
Okay, so when we're talking about K through 12, that can be considered true in most circumstances because most of the private schools are not federal recipients of federal financial assistance. But when we're talking about post-secondary, like colleges, law schools, grad schools, etc., trade schools, they almost always do receive federal financial assistance. Unfortunately, you will sometimes see an intentional, you'll see them intentionally avoid direct receipt of the money to avoid coverage under 504. So like one example that probably people can easily understand is if someone is receiving a voucher to attend a private school and it goes to the parent and then the parent pays the school, that money's not going directly to the school. So schools usually say they're not covered under those circumstances. So the answer to the question is short, kind of true, but not always.
Okay. Yeah, we did have a few attendees here today under exactly those circumstances, wondering if their child is attending a private school with a voucher, would their services be at peril, in peril, excuse me. Okay. Now returning to about people with disabilities being impacted by the DEI changes. Some people are wondering if there are protections under the Americans with Disabilities Act that would afford some protection to people with disabilities who might otherwise be impacted by the changes with DEI.
Yes, so the Americans with Disabilities Act definitely offers protections. Under that law, a person has a disability if they have a physical or mental impairment that substantially limits one or more major life activities, and accommodations are whatever is necessary to level the playing field for the person, whether we're talking about higher education or education in general in the case of like a private school, right? So that's one situation where let's say a school is not receiving federal financial assistance for like a K through 12 student. If they're like a private school that's open to the public, meaning they're a public accommodation, like anyone can decide to like pay the money and have their student attend, they can't discriminate on the basis of disability, and they do have to provide accommodations unless those accommodations would be a fundamental alteration of their program or would pose an undue financial hardship. But those things are pretty difficult to establish when we're talking about like very basic accommodations like extended time, private setting, assistive technology. So ADA is definitely protective there.
Okay. You talked about financial hardship, and that leads to another big question, and that is about funding, and just how much funding for special education actually comes from the federal government versus from state funding.
So unfortunately, I don't have the specific numbers, but in preparation for this, checking with different resources, I have not seen any indications that funding will immediately be impacted, right? So at least for the current school year or next school year, hopefully things are good to go. But even if, let's say, the federal government froze all funding, and talking with my colleagues, it seems that most people agree, or a lot of people agree, that the states would still be obligated to keep up with the programs, right? To keep up with the special education supports and services, even if they're not getting money from the federal government. So that's another protection there that I think is a safeguard that's built into the statute.
Mm-hmm. Okay. Yeah, I think we've done a bit of digging on our end as well. It seems like federal funds are approximately 13% of special education services, and that's a country, wide, so it may differ in your state. So it's definitely not 90%. It is, right. It is low.
Like the states would need to make up the difference somehow.
Right. Right. I mean, it is still 13%. So that is going to have an impact, but it's not going to mean necessarily an end to services. Right. Okay. You also talked about the IDEA stipulating special education living under the Department of Education, and the new proposal / executive action to move it to Health and Human Services. You said that there's a legislative process that would need to be followed for that. Could you quickly brief us on that? And my apologies if you did, and how people can get involved in speaking out regarding that proposed change.
No problem. I see the 5-minute timer came up. Can I go back to one of the slides?
Yes.
Okay.
Yes. I think that's just for our view.
Oh, oops. Okay. So let's go back here to how federal laws are made. We would need for someone in the House or the Senate to introduce a bill, and then it would need to go through this process. So if they wanted to amend the IDEA, all of this has to occur. So There are a lot of opportunities for the public to testify, to demonstrate. You want to show up and do that. For sure, lobby your representatives, make your voices heard, and let them know you don't want them to vote for this. So there are many opportunities to create speed bumps for something like that to happen, and hopefully ultimately stop it from happening.
Mm-hmm. And you did share at the end there some of the resources people could use to follow the news, essentially.
Follow the news, contact your federal, state, and local representatives, see what's happening in Congress, right? So C-SPAN, it's a live feed. See what's happening without it being summarized or without spin being placed on it from media sources. See for yourself.
Right. And someone did write in, you were talking about back in the day that the department was actually called Health, Education, and Welfare. And essentially in 1979, please correct me if I'm wrong, when the Department of Education was created, it split. So we had the Department of Education, and then basically Health, Education, and Welfare became what is now HHS. So
it might have been workforce. I know it was HEW. It might have been workforce, Health, Education, and Workforce.
Gotcha.
And presently, as an example, there's even a committee, I think, in the House that is still Education and Workforce. And it kind of makes sense why those two things align, right? Because education is what helps to get you to participate in the workforce. But right now, just for HHS, Health and Human Services, to take on the responsibilities of Education Department after it's been fine-tuned for decades now, it's kind of crazy.
Someone wrote in, this is like a whole nother webinar altogether, but I will just acknowledge that, yes, the state of Texas just voted, well, I think there was a vote about privatizing all K through 12 education. That is a whole nother wrinkle.
Yes. And, Texas isn't the only state that wants to do that, unfortunately. So definitely see where your state stands on this and what you can do to present an alternative viewpoint.
Right. Again, because if it's a private school that is not directly receiving federal funds, they would not necessarily be, wouldn't necessarily have to comply with IDEA or the 504. That's correct?
Correct. And for ADA, yes, they would likely be subject to that. But if they're a religious school, then they're exempt from that.
Oh, another wrinkle, yet another wrinkle. Is it any wonder that we feel overwhelmed? Okay. We're just about at time. I'm just looking over my notes to see if there are any others that are pressing. I mean, they're all pressing. But maybe if we could just touch very quickly on, I think there were a number of parents of college students here. And I think it became pretty clear that they could potentially be impacted, especially by changes to IDEA. Is that correct?
So if you're in college, IDEA changes wouldn't impact you, but 504 changes would.
Gotcha. Right. Okay. So yes, your college student may be impacted. Essentially,
I'm sorry. And also, before I forget, just to clarify, even if there are no changes to 504, what's happening with OCR uniquely impacts college students, because that is, one of their primary means of enforcing their civil rights.
Right. So that's the Office of Civil Rights, which you mentioned has experienced about a 40% cut. And that was just about a month ago. And I think I did see some reporting already of families who have seen, as you stated, that their cases have been frozen. and very little progress being made. So, okay, well, that is not the cheeriest note to end on, but Mary, my head is filled with information. This was extremely informative. Thank you so much for joining us today and for contributing your voice and your deep knowledge to the ADDitude community. We very much appreciate you.
Thank you. It was a pleasure to present before your audience. And I will just say, while much of this is disheartening, I hope you do understand that we have tools, right? And we have power. And it's important that we not cede that power at the state level and at the federal level and in our communities, in our schools and our neighborhoods.
Thank you. That is a much better note to end on. And thank you so much to all of today's listeners. Your questions were amazing. If you would like to access event resources, you can visit ADDitudemag.com and search for podcast 554. The slides and recording will be posted a few hours after the live webinar. If you are listening in replay mode, you can simply click on the episode description. And please know that our full library of webinars is available as a podcast. It is called the ADHD Experts podcast, and it's available on most streaming platforms. We hope to see you this Friday. We're doing a live Q&A called Solve My Problem with Dr. Sharon Celine, and she will answer any questions that you have about anything in real time. All things ADHD are welcome. And to make sure you don't miss any future ADDitude webinars, articles, or research updates, please sign up to receive our free email newsletters at additudemag.com/newsletters. Thank you again, Mary, for joining us today, and everyone who contributed to this discussion. Have a wonderful afternoon.